Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1059 et al. Tenaska Clear Creek Wind LLC petitioner versus Federal Energy Regulatory Commission. Mr. Super for the petitioner, Ms. Pasella for the respondent, Mr. Binet for the interveners.
Good morning.
Good morning. May it please the court, David Super with Bracewell. On behalf of petitioner Clear Creek Wind, I'd like to reserve 2 minutes for rebuttal. Clear Creek is a wind farm in Missouri that's interconnected to a grid that's operated by Associated Electric. But this case is about the rules for allocating costs to address potential impacts from that interconnection on neighboring grid operated by Southwest. And just to provide a very brief overview, I'll be addressing 2 points on the merits today. First, Southwest's practice of studying the Clear Creek project using network service standards resulted in the allocation of costs to Clear Creek that have no relationship to the service being provided to the project in violation of the cost causation requirement and the Federal Power Act. Southwest studied the project using network service standards, which assumes that the Southwest system would support full deliverability of the project's load on Southwest system during peak periods. But the obvious problem with that assumption is that the project is located on an adjacent system and will not serve load on Southwest system. In fact, in order number 2023, FERC found that using network service standards for affected system studies results in a mismatch between service and costs in violation of the cost causation requirement. And second, on the merits, even if using network service standards were appropriate, Southwest's allocation to Clear Creek of 100% of the cost to remedy pre-existing overloads on the Southwest system violates the cost causation requirement because Clear Creek did not cause those overloads and shouldn't have to pay for them. But before going further.
Now, Clear Creek downgraded to the Energy Resource Interconnection Service, but are you now suggesting that they won't use any of the NRIS system?
Well, that is correct, Your Honor. Because of the study using network service and the allocation of $87 million in network service costs to Clear Creek was forced to downgrade to energy-only service in order to avoid insolvency. Now
you spent $266 million toward the project. So if we're looking at cost causation, discuss a little bit about that benefit and burden. Like, why put this much money into the facility if there's not some benefit to you?
Well, Your Honor, Clear Creek is perfectly willing and has agreed to pay the $15 million in energy-only related service for upgrades to the Southwest system. And that's appropriate because that is the level of service that Clear Creek has requested and will receive on Associated Electric's system. But it should not be allocated any costs due to network resource service because it has not requested that level of service on the Southwest system, and it won't receive that level of service on the Southwest system.
Well, you have, I gather, expressed your intent to upgrade to correct?
That is quite right, Your Honor.
What happens then?
Well, in the agreements with Associated Electric, whereby Clear Creek downgraded to energy-only service on the Associated Electric system, Clear Creek has the right to reopen that issue and revert to network resource service on the Associated Electric system. And that's an important right because
Will you then face the cost you're complaining about now?
Well, Your Honor, that is a question because Southwest has said in its briefs that if Clear Creek were to revert to network service on associated electric system, Southwest would restudy the project using network resource service. And that's the fundamental problem that we think is improper in violation of the cost causation requirement. And that restudy could very well result in network service costs to Clear Creek that we believe are in violation of the cost causation requirement.
Could come out exactly the same way, correct?
It could, very, very much,
And
yes.
would any of those costs be passed on to your purchasing customers?
I'm sorry?
Would any of the costs be passed on to your purchasing customers?
Clear Creek is not in a position to pay the network service costs of $82 million. That's why Clear Creek downgraded to energy-only service, because it was faced with impending insolvency due to those ruinous levels of costs. And so that's why it had to revert to a lower level of service that is not as favorable to Clear Creek as the network service is.
We don't have that agreement. The November, I think it is, agreement with Associated, right?
That is correct.
Is there a reason?
Well, the agreement is confidential, to my understanding, but it is in the record. I think both sides have pointed out the fact.
Document's not in the record. You
That
mean
is-
references to, that it exists is in the record.
That is correct. And both sides have pointed out to the fact that Clear Creek does have the ability to revert to the greater network service.
As I read it, you had the ability to request that.
That is true, Your Honor.
So
we can
what value is that?
Well, it is valuable because network resource service is a much more valuable level of service. Generators on associated electric system who have the network resource level of service allow Associated Electric to utilize those generators to serve load. So it's actually, network resource service is actually a valuable service to Associated Electric as well as Clear Creek. Clear Creek, of course, benefits from the higher level of service, but it's offering a higher level of service to Associated Electric as well. And so there would be incentives for the parties to agree to allow Clear Creek to return to network resource
I'm not
service.
sure what you got out of this agreement. Does it hold your place in line?
Well, if we were subject to restudies based on network resource service, presumably Clear Creek would have lost its place in the queue. But Your Honor, we think that is the fundamental problem, that the project has already been studied based on energy-only service, and Clear Creek is willing to pay that $15 million. It's our view that we should not be studied under the resource service standard. And again, that's what...
So this is standard in the protocol for Southwest, right?
I'm sorry?
This procedure is standard in the protocols internal to Southwest.
That is correct. Southwest utilizes both network resource service and
They do
energy-only
this
service.
and I believe FERC has approved it, approved it on the ground that it's a prudent step.
Well, Your Honor...
And in this instance, where you will yourself say you want to return to network service as soon as possible,
That is correct.
it certainly seems like a prudent step.
To return to network resource service.
No, for Southwest to evaluate, to do the study based on network service.
Well, Your Honor, Southwest studies Clear Creek utilizing the network service standard based on an assumption that Southwest would be utilizing the Clear Creek project to serve load on Southwest system. That's why Southwest does that study level. The fundamental problem with that assumption is that it's false. Clear Creek has never requested network level service on Southwest system, and Southwest has no obligation to provide that level of service.
This is your key point, right? What you're reserving the right to do is return to network service on Associated Electric, not on Southwest.
Your Honor, that is 100%
why
correct.
you're saying.
That's exactly correct. We are unable to return to network resource service on our host system, Associated Electric, because Southwest is holding us hostage because it's been studying the project based on network resource standards that, again, apply to a level of service we have not asked for and will not receive on Southwest
Right,
system.
so the obstacle for you on that claim, just taking it on its face, is that in these orders, FERC said that it had just very recently in 2 other orders approved this practice, allowing the transmission organization to decide whether to assess this type of situation under network or energy resource. And in your opening brief, I didn't see where you addressed those 2 orders that FERC relied on.
Well, the order in our opening brief was the notice of proposed rulemaking. The final rule was issued about a month after our initial brief. And of course, we did point to that final order in our reply brief. But I think that
And the final order is prospective only. And your argument is that it was arbitrary and capricious even before that rule was final.
that's exactly right, Your Honor. We're not asking for this court to retroactively apply order number 2023, in addition to the recent denial of the rehearing request on order number 2023. We just ordered 2023.
Because I wasn't sure of the way you phrased it. Isn't it the case that you've always sought access through Associated?
We do have access through, so we're attached to Associated.
That's always been the only way in.
That is exactly correct. And this case is about assessing what impacts our use on Associated Electric have on Southwest. And the question is, what standard does Southwest use to study our impacts? And our argument is they're studying us based on a standard that we don't receive from them and haven't requested. And I think Order 2023 by FERC is very important because we're not asking this court to retroactively apply Order 2023, but in that order, FERC adopted the exact arguments we've made in this case. FERC has said in that order that the use of network resource service for an affected system study results in a, quote, mismatch between service and costs. Every single one of the arguments we made in this case, FERC has now adopted in Order 2023. So we're not asking you to retroactively apply that order, but we are asking you to reach the same decision that FERC reached in Order 2023 in this case, because FERC has made no bones about it. It has said that studying, doing an affected system study utilizing energy-only service addresses all of the potential reliability concerns that may arise. It's not necessary to study an affected system using network resource service, and to do so is creating a violation of the cost causation requirement because there is a fundamental mismatch between the costs paid and the services provided.
That order is pending petitions for review, right?
That is correct, Your Honor. It's on abeyance at the moment.
We don't even know whether it'll ever take effect.
Well, I do agree that issue is now pending before this court. However, I would posit that this case is now the lead case far ahead of that one on this exact issue. And so this case could be influential on that
And the
one.
other proceeding,
I'm sorry?
are you objecting in the other proceeding?
Are we objecting to the result of order? No, we think that FERC got it right in Order 2023.
So you're there just as an intervener?
We should. We haven't yet, but
Okay.
that we're asking for this court to do the same thing that FERC has now done in Order 2023 for the exact same reasons that we raised in our brief. That there's no reason to study to do an affected system study based on network resource service.
Can you operate under NRIS with respect to AECI, but then ERIS with respect to the Southwest at the same time?
No, Your Honor, because in order to get network resource service on Associated Electric System, Southwest has taken the position it must study the impacts of our interconnection request using the network resource
And
system.
what other generators do you hold responsible when you're talking about that it's not fair to you to bear all of the costs?
Well, that's a kind of another issue. That the other problem with FERC's orders in this case is they approve Southwest's allocation to Clear Creek of 100% of overloads that were caused by other parties. And Clear Creek should pay for its portion of those overloads. But in one instance, the Nashua transformer there were pre-existing overloads that were 3 times greater than Clear Creek's incremental impact.
But is it their argument that you are the but-for cause, that your particular impact causes the need for the upgrades?
Really 2 answers to that question, Your Honor. That first, the but-for policy is a FERC policy, and it doesn't supplant the requirement of cost causation, which is fundamental to the Federal Power Act, as this court has recognized. But the other point is that FERC has never really explained how Clear Creek could be the but-for cause of an upgrade when there are greater pre-existing overloads on that facility.
Because those overloads didn't require additional infrastructure.
Well, then,
Overloads over a rating, which is obviously a prudent ex-ante rating, and it turns out the system is working reasonably well with what they call an overload.
well, Your Honor, in the case of the National Transformer, there were pre-existing overloads up to the level of 110%. And then Clear Creek comes along and adds 3%. And so if
I
that,
understand that. You're the marginal customer. It's just marginal cost causation. It's a fundamental utility regulation principle across all of these schemes.
well, Your Honor, I think this court has rejected schemes where one party that causes 1/3 of the overload is required to pay 100% of the costs, and the parties who cause 2/3 of that overload get away scot-free.
What case are you thinking of?
Well, I'm thinking of Consolidated Edison.
Yeah, totally. That's just totally different. That was the case with the huge zones, right? I mean, it was not, that was like astrology.
Well, Your Honor, I do think that case focused on the fact that the de minimis process being used in that case, which admittedly was different, produced absurd results. And I think the split
What's your better case or other case?
well, Old Dominion is another case that recognizes the cost causation requirement. And there, this court recognized that a party that was receiving only 50% of the benefit of a particular project should not have to pay for 100% of the costs.
Was
And
that a planning case?
I'm sorry,
Was that a capacity planning?
there was a transmission case.
It was a transmission interconnection?
It was not an interconnection case, but in our view, Your Honor, that the policies that underlie transmission are the same that underlie interconnection.
That's not the commission's view.
Well, in the end,
That's not just this case. That has been the distinction they've maintained.
I think in the Entergy case, though, this court said that interconnection was just a subset of
But didn't
transmission.
you also benefit, I think the example was used that there were 24 constraints in another setting.
You're right, Your Honor. Yes, that's the, we've been kind of calling that the you win some, you lose some approach that Southwest applies to its de minimis practice. And the idea is that because there are other overloads where Clear Creek may not trip the 3% de minimis threshold, that's considered somehow a benefit. But the problem with that is FERC does nothing to say whether those alleged wins are in any way roughly commensurate with the $87 million in known costs, the loss that Clear Creek is suffering based on the overloads where it is being required to pay 100% of the cost. So there's no roughly commensurate analysis being done by Southwest and FERC in that situation. It truly is just, well, you win some here, you lose some there, but no attempt to.
You're not arguing cost causation now. You're arguing some kind of equitable proportionality.
Well, this is actually a response to FERC's argument on cost causation. They say that.
Well, that's just explaining how it works, right? And then the next person next connection that requires an upgrade on those will pay for your capacity. That's just an inevitable consequence of how they operate.
Well, the fact that it is an inevitable consequence of the operation of Southwest's de minimis practice, Your Honor, I would suggest doesn't mean that it satisfies the cost causation requirement. Because if you've got a situation where the accumulation of pre-existing overloads grows to some unlimited amount, but no pre-existing customer trips the 3% threshold, and then along comes some unlucky customer who does, there's no cost causation basis upon which that subsequent unlucky customer should have to pay for the entire overload that's been caused by many parties. And that is a fundamental violation of the cost causation requirement.
You're just exploiting their terminology because it's an overload. It's functioning properly, and now you need something that would require upgrading the system.
Well, Your Honor, if there's a 10% overload, 10% over the rated capacity, and Clear Creek adds 3% to that overload, if the 10% isn't causing any kind of reliability problems, then there's a question whether there's an overload problem to begin with that needs to be corrected by Clear Creek.
Well, as I say, you're just exploiting that term overload. It's obviously load.
Well, I'm not sure I'm
over a rating that was ex ante, and that's was probably prudent at the time, but turns out perhaps with later efficiencies or something they could carry more.
Yeah, well, I'm not sure I'm exploiting the term overload. I mean, there is a 10% overload on the Nashua transformer that presumably is causing a reliability problem.
But they said it isn't.
Then if it isn't, then why does Clear Creek's 3% addition to that 10% overload all of a sudden cause the...
At some point, obviously, there will be a reliability problem.
Well, I think that's where it becomes so arbitrary, because they decide there's a reliability problem when some unlucky customer happens to have a 3% impact. And it's completely arbitrary. You could have 15 customers with a 2.9% impact and a 50% overload beyond capacity. And yet one customer with a 3% de minimis threshold somehow trips that problem, and all of a sudden you have a reliability problem.
You've asked for vacator as well. Is that your only acceptable remedy, and what would you find to be the fundamental flaws in the commission's?
Well, Your Honor, we would ask for vacatur and remand back to FERC. And the problems we identify here, number one, Southwest was incorrect, and FERC was incorrect in allowing Southwest to study the Clear Creek interconnection using the network service standard, a level of service that Clear Creek has not requested and will never receive on the Southwest system. That's number one. Number two, the fact that Southwest is requiring Clear Creek to pay 100% for pre-existing overloads that Clear Creek did not cause, at least in their entirety, and that other customers of the grid will benefit from. And third, the fact that Southwest and FERC are using this arbitrary 3% de minimis threshold to justify requiring the unlucky customer who comes along to have to pay for pre-existing overloads on Southwest's system.
Counsel, in this situation, is there a practical difference between us vacating and not? If we were to agree with you on one of these grounds, we remand, is there actually a difference between vacating? It seems like you've effectively been denied what you want already. And normally vacator matters when there's sort of ongoing reliance on an approval.
Yeah, I'm quite confident that my client would be satisfied with a remand and an instruction to FERC that Southwest is not to use the improper network resource standard in studying the Clear Creek
then
project.
on the cost allocation issue, I just want to understand a little better what exactly you're proposing. We could use Nashua as an example. Are you saying there's at least, well, there could be many different versions of it. You could be saying that it's reasonable to require an upgrade when a 3% contribution comes in, but the upgrade should somehow be calibrated to that 3%. Or you could be saying we should actually go and charge the prior de minimis contributors to contribute to the bigger upgrade. Presumably could be many other things as well.
And the second
proposing.
Yeah, the second part of that question is very complicated. I think our first proposal is this. The usage of the network resource service, that accounts for all of the
I
network
understand
upgrades.
that.
So
I'm talking about your complaint about this application of the de minimis threshold.
yes, I think, Your Honor, the thing to do there is to require Southwest and FERC via Section 205 of the Federal Power Act or Section 206 to revisit Southwest's process for doing these kinds of allocations, because a system whereby an interconnection customer is being required to remedy pre-existing overloads that far exceed that customer's contribution is a violation of the cost causation requirement. And it is incumbent upon the agency and Southwest to figure out a better way to do it. See, my time is up. So
We'll save 2 minutes for rebuttal unless you have questions now. Okay, thank you.
thank you.
Good morning, Your Honors. Beth Pasella for the Commission. I think I'm going to start with the use of network resource interconnection service standards. The Commission has already found that Southwest's use of NRIS standards is just and reasonable, and have found that in the Mid-Continent case. So Tenaska's burden here is to show that that's no longer true. And the Commission explained that it's appropriate for Southwest to study the interconnection's effect on the system using the higher level interconnection service Tenaska requested to ensure that the transmissions that Southwest system will remain reliable and that there will be proper cost allocation. Energy Resource Service only allows Tenaska to put its generation on Associated Electric system on an as available basis. And the NRIS service allows them to do it basically as a firm service, is continually, as much generation as they have, they can put on the system. And the effects are certainly different on Southwest system, whether it's ERIS service or NRIS service. We know that. So, and the Kelly affidavit explained that Southwest does this to ensure that its system can accommodate the level of interconnection service requested, not that there will be deliverability on Southwest system. And the Commission always, in the Mid-Continent case at paragraph 60, the Commission explained that, let me find that. The Commission explained that Tenaska, that the study does not, that SPP does not study the affected system interconnection as if the generator's output will be delivered on SPP system. It studies it as if it's going to be delivered on the host system. And that's in paragraph 60 of Mid-Continent 171 FERC 61275. The Commission explained Southwest's affected system study syncs the interconnection request into the host system's footprint. So it's the effects of syncing it into the deliverability on the host system that still causes these effects on the Southwest system. The flows happen automatically on Southwest system just by virtue of the deliverability happening on the host system. And that's why Southwest studies it under this higher level NRIS service.
So in the please. In the 2023 order, FERC has now ruled that SPP shouldn't do that.
That's
So
right. And
the way you just explained it made it sound sort of inevitable that network resource standards should be used. So what's changed?
so a different record, Your Honor. And let me first say, and I'm sure you know this already, but I can't, as FERC's lawyer here, not point out that that is what the Commission has said in Order 2023 is literally irrelevant here. The court cannot, I mean, in Brooklyn Union Gas, for example, as we pointed out in our brief, and in the McLeod decision, talked about in the Brooklyn Union Gas decision, the court absolutely said the subsequent decisions are irrelevant in any event. We will not reach out to examine a decision made after the one actually under review. The court said an agency's decision is not arbitrary and capricious just because it decided something different later. So understanding, and I'm happy to talk about it, but it really is irrelevant here. But if it weren't irrelevant, it just, the Commission had a different record. You know, it was a rulemaking, and it didn't involve just the record here. It involved all kinds of matters. And that, again, will be addressed by the court on review later on. In addition to that, as
Can I ask about the other issue, unless?
Of course.
So one thing Clear Creek says is that the way you've justified imposing all these costs on them is, well, you're the first interconnector that required an upgrade. And what they say in response is, but your way of determining when an upgrade is required is arbitrary. Because, for example, you can have a 10% overage, a 10% contribution, and the policy says no upgrade is required. But if the first interconnector had been a 3.1% instead of 2.9%, the policy would say an upgrade is required.
What the commission explained about that is that the use of the de minimis threshold is consistent with cost causation because it's consistently applied to everybody. So, and it does matter that it cuts both ways. I mean, that's not just a side point, that's part of it. It's consistently applied and it cuts both ways. So an interconnection customer and
So put aside the cut both ways point. You agree it seems very odd that one interconnector, one generator responsible for 30% of this overage is being charged for 100% of the cost?
No, it isn't, Your Honor.
That's what I would love to hear more.
Because use of a de minimis threshold is appropriate. The commission found that the use of de minimis threshold is
using a de minimis threshold to say when someone comes in with a very small addition to say we're not going to require them to pay for an upgrade makes a lot of sense. It's a different question whether it makes sense to tag the last person in line who comes in after 10%, 20%, 30% overages and then says, well, you've got a 3.1% and everyone else had 2.9, so you're going to pay for an upgrade to account for 31% of a capacity upgrade.
So that's literally how de minimis thresholds work.
You could attribute the costs in other ways. You could say, we're going to let those de minimis contributions add up until our annual planning process says they're actually creating a reliability
That is how it
problem.
works, Your Honor.
Then why isn't that what happened in this case?
Because it didn't end up being a reliability problem on the system as a whole. Interconnection customers have to pay for network upgrades that are necessary to accommodate their own interconnections. So, and as long as they are above a de minimis standard. And so, and if the de minimis uses, the de minimis upgrade effects added up to enough to cause a reliability problem on the system, it would be part of the base case. It would be accepted and it would be addressed in the annual transmission planning process. And so that is packaged into all of this.
I appreciate that. So I guess what remains elusive to me is why, if they come in with a 3% increase, why aren't they required to make an upgrade that offsets that 3%? That
is what they're doing. They are making an upgrade that they're not complaining that the upgrade is too broad, that there's no argument here, and there could have been one.
So is this same exact upgrade at the same exact cost, whether there was a 3% overage or a 13% overage? In other words, that seems to be their whole complaint, is that the upgrade gets bigger as the overage goes up.
I don't think they're saying that.
Required them to do this kind of an upgrade instead of this kind of an upgrade.
I don't think they're saying that the upgrade gets bigger. I think that they are solely responsible for the upgrade. I think I've not seen any complaint in this case that the upgrade is larger than it would need to be to accommodate their argument. And perhaps they were, I don't know. I've not seen that argument, Your Honor.
If Petitioner here is correct, and you were to you could charge them only, they're taking it from 110 to 113 of the rated capacity. Then you would go back, I guess you would have to go back to the previous people who came in without paying for upgrade facilities and say, surprise, you've been on the system for a while, but now you're going to be charged an additional, whatever, tens of millions of dollars.
That's right, Your Honor. I mean, it defeats the whole purpose of using the de minimis threshold in the first place. And so really, I think.
Well, it also strikes me as creating significant problems for the inframarginal customers who might not have requested service had they had borne that kind of a price tag.
That's right, and that's not provided for in the tariff to go back to prior queued customers to,
And what would happen? If it's even viable, would it just result, I shouldn't say just, would it result in then that going into their rates?
if you,
The additional expenditure would go into their rate base, right?
I guess it would go into the rate base, but the point is, it seems like retroactive rate making.
Well, yes, where's the
Yeah.
filed rate doctrine?
Right.
in all this?
So but Judge Garcia, I just want to say, if you can't really separate out the part about it cuts both ways, and I know for purposes of discussion, that's fine, but that is part of the commission's decision-making. That's what makes it roughly commensurate. It's consistently applied, minimum threshold is consistently applied, and it cuts both ways. And roughly commensurate doesn't require that the commission does it ends up for sure being even for you, exactly even over time. This is how it works. And it's a practical, as the commission has found, just and reasonable way.
Yeah.
For,
I just want to make sure I understand your answer on something earlier.
Yes, Your Honor.
So it seemed to me that there was a shared assumption in the briefs that, like, in some practical sense, what Clear Creek is required to pay for is more because there were pre-existing overages.
they are paying
Not that
more.
it's just 100% of what they would have been responsible for, even if they were first, but that it takes more money to remedy 13% overage than a 3% overage. Is that correct?
I apologize that that wasn't addressed on the record here. I just don't know the answer to that.
There's one piece of evidence that bears on this. Some of the upgrade involved upgrading lineage. And the cost of that is per mile. The cost of putting a step-up transformer is fixed.
That's right, Your
It's
Honor.
not responsive to degrees. It's lumpy capital. And if it costs $10 million, there's no way to just put in a third of it. You have to put in the whole thing.
Yeah,
But with mileage, it's obviously, clearly responsive to the distance.
that sounds right to me. I just don't know the answer, but what I can say is I have not seen an argument from Clear Creek saying that the upgrade should have been smaller. You either have an NRIS upgrade or you don't have an NRIS upgrade, is the way I've understood the case, and that's my understanding.
Now,
All right, so-
The orders don't speak to that.
do the prior contributors bear any responsibility once you've asked Clear Creek to pay for the upgrade?
No, they do not, but they pay for
Even
their
though they'll
own,
benefit?
but it is really an illusory benefit because they
Okay.
get the interconnection without having to do any upgrades anyway, because they're not the but-for cause of the upgrade.
Now, why did the actual upgrade cost change over the course of 4 years? It seemed like 11 times or so. You start out at 33 million, got as high as 763 million,
Yeah,
back down to 100
Yeah.
million. I mean, why would that not be?
I can't explain the 760 million, that one, but so, part of it was originally, and again, it's not being litigated here, but Southwest improperly left out 4.5 gigawatts of service. So that was left out of the NRIS part of the original study. And when Southwest was when higher queued interconnections dropped out, Southwest appropriately did a restudy, and the commission found that it was appropriate for them to do it properly. It wouldn't have changed, though. If they hadn't had the opportunity to do a restudy, that 4.5 gigawatts never would have been considered. But in doing it, it was proper. So that made a big difference. And then another factor was, I think it's COVID, because it's COVID time. The costs went up so much because in 2020, the cost of labor and materials were so high. So it doesn't say it's COVID, but it was during that time period, it was 2020. So I think that's what caused the cost to go so high in part.
In your brief, in terms of justifying reliance, or pardon me, proving the company's Southwest reliance on the NRIS
Mhm.
level of service for evaluating cost. You referred to in two places, this is at 44 and 45 of your brief, maybe a little bit beyond, to the justifications being reliability and proper cost allocation.
Right.
Now,
That's right.
reliability seems, I see how you could say, it's clearly if they're planning, if they're anticipating a network service when in fact energy service is going to be required, that gives them a cushion, a guarantee that they'll never be overloaded with that. But why does that improve proper cost allocation?
Because it acknowledges the but-for cost aspect, who the but-for causer is. And so if you are causing NRIS level flows on Southwest system, you should be paying.
Okay, but then if they're requesting only interruptible service, why does that still apply?
If they're requesting only interruptible service, then it would only be studied under the ERIS level.
Maybe I used the wrong term, but I'm energy service. Okay.
Then, right, that if all they requested was ERIS service, Southwest would study it only under ERIS service. It's only if.
So, but now, I thought now they did request it. They downgraded.
Now they've downgraded. And so Southwest has explained in its brief that means, and that's why this case is moot, which we haven't talked about.
Well, but if we ask, is the harm to them imminent, right? Part of the Lujan.
But it's not because.
Well, since it's quite clear that they want network service and will apply for it.
I understand that, Your Honor, but it's just speculative. It's speculative.
That's my point. It's not.
It's speculative that
they need and want network service, and they've agreed to have some kind of an arrangement with.
I understand that. That may not be speculative. What is speculative is that Associated Electric's third party will agree to change the purchase power agreement and go back up to network service. And they may or may not need network service from Tenaska at that point. They might need it, they might not. They're buying all of the generators' power, all that they generate. They may not need it at that point.
All right. So that was the basis for your argument on standing. Now,
just mootness. I mean, yeah.
Our mootness part.
Yeah. Which we didn't argue because it happens.
But now just take that out of the equation.
Okay, sure.
And tell me why it is that planning, evaluating the cost for network service is justified for cost allocation purposes when all they want is energy service.
Now they're responsible only for the energy. There's one ERIS upgrade, and that's all they're responsible for now. They never pay the costs to have the upgrades done, the NRIS upgrades done, and they're no longer responsible for them. Those costs are gone. That's why it's moot. I mean, those costs they're going down to ERIS service meant that the NRIS upgrades they're no longer responsible for them. Someone else will pay for those if they're necessary.
So all of the petitioner's argument was unnecessary here?
No, it was necessary when mootness is an in-time thing, right? So when they filed their brief, they hadn't yet gone down to ERIS service only.
No, but they have, before they presented the argument,
yes,
half an hour ago.
Yes, yes. There's no more, they have no obligation to pay for these upgrades, for the NRIS upgrades, and they have no problem paying.
So it's only then, in the event that they later switch through Associated, come back with network service, that they would incur this cost.
And SPP's position is that FERC agrees with that, is that we don't know what those costs would be because they would have to be evaluated at that time. As SPP's brief explains, the practical effect of Tenaska Clear Creek going from NRIS service to only ERIS service means that they're not responsible for those upgrades and they're taken out of the queue, and we don't know what the situation would be at that point. They might be.
What could change? Yeah,
anything could change. They could have. I can't imagine they'd have the exact same upgrades. It's a period of time later. Things change. We don't know what the upgrade level will be. We don't know if.
But why would you said just because the time passes? Why would that change?
Because the factual scenario would be different. Instead of the grid at that point, the de minimis impacts on their impacts on the grid might be de minimis at that point, because the grid will be different.
Because someone else will have.
Yeah, someone else will have paid, or just because of the annual changes that happen to the grid. All kinds of upgrades happen all the time on the grid.
The costs could also go down, right?
Costs could absolutely go down.
Okay. And one key difference between standing and mootness is who bears the burden, right? So maybe if this were the situation before this was started, that uncertainty would count against the petitioners. But when we're talking about mootness, it's on you and Southwest to show it is unlikely that they will re-pursue network service.
I think, Your Honor, it's unlikely that I don't think it's speculative that they might ask for it. It's just speculative whether they would get it and whether they would have the same package of costs. They might have, theoretically, they'd end up with no network level costs. We don't know. We literally don't know, but I feel confident in our merits, and I'm not gonna, belabor the point on mootness.
You are taking the position the case is moot.
I am, yes, we
Okay.
are, Your Honor, yes. I'm just looking at my notes to see if I've talked about everything I want to talk about.
Well, just a couple of things.
Yes,
One
Your
is that Clear Creek is challenging how you've used the network modeling studies and whether you've been consistent in that regard. Would you like to speak to that?
I'm sorry.
Well, just the modeling, just your whole study with respect to the network modeling, they seem to have challenged that you've been inconsistent in your application as you do these studies.
I don't know what issue that is. I'm sorry. I'm not getting the question. I apologize. I don't, what claim is that they're making?
Well, they've just indicated that, that not commission.
I know what you mean. I know.
SVP has
Yeah.
been
Yes.
inconsistent in applying the modeling practices and the thresholds just generally. The SVP has done so. Do you have any response
I
to
don't
that?
recognize that argument. I don't know if you're talking about their being curtailed. Is it about the curtailment? Is it? I don't recognize an argument that they've made that we're not.
Okay, let me just move on from there. And then just on vacatur, you want to respond to that would be their request?
I mean, I think that's Your Honor's decision. We obviously think that order should be affirmed. The commission certainly could give more reasoning if the court felt that was necessary. I think the orders actually answer everything that was raised to the commission on rehearing. There are a number of things that weren't raised to the commission on rehearing that aren't properly before the court. And, but I think that's really up to Your Honors. And certainly we don't think vacator is appropriate, but we leave that to you.
Okay,
Thank you.
All right, thank you.
Good morning, may it please the court. Matt Bennett for Intervenor Southwest Power Pool. I'd like to start with the question, Judge Childs, you just asked that my colleague, Ms. Pasella, was not following. I believe that Tenaska Clear Creek has suggested that SPP has not applied the NRIS or the Network Resource Standard consistently. It has throughout its interconnection process. The study that they're talking about in their brief and in the underlying record in this proceeding is a planning study, a conceptual study that SPP and its neighbor Mid-Continent Independent System Operator have decided to pursue outside of the interconnection process to identify regional or interregional upgrades that may help alleviate problems along their border. It has nothing to do with the interconnection process. Every generator, whether they connect to SPP or whether they connect to a neighbor that requests the higher network level service, is studied under that. And they're also studied under the energy service to give them an idea of what the cost differences would be. Judge Childs, you also asked a question about why were there so many different studies and changes in the cost. Well, the answer is this is a very complex process. If a generator drops out somewhere, SPP has to determine whether to restudy. Restudies cause differences in cost, cause differences in flows. You know, throughout the system. SPP is analyzing the Mid-Continent system, the SPP system, and the AECI system all at the same time. And typically what happens is, this is not unusual, but typically what happens is the generator waits for the results of the studies before they pursue construction. In this case, what Tenaska did is they entered an interconnection request with AECI. They initiated the interconnection process with SPP in August of 2018, and only 16 months later entered commercial operation. The way they rushed through this process without waiting for the results of the studies, it's no surprise that their interconnection costs have changed. I mean, that's just the nature of the business. Most generators wait until they actually have a little bit more certainty about the costs. If you look at two of the generators that Tenaska complains about, one of them is the White Cloud generator, I believe, and the other is a Mid-American Energy generator. Those two generators both entered the respective queues before Tenaska, but they ended up not coming into commercial operation until after Tenaska. And the reason for that is they waited for the results of the studies. Tenaska didn't do that. With respect to the NRIS, and I apologize for the acronyms, I know this court doesn't like acronyms, but in the underlying docket, SPP submitted expert witness testimony to exactly why we apply the NRIS standard to NRIS requests on neighboring systems. That's at JA 170 to 171. FERC credited that testimony in this case. FERC has to make its decision based on the record. We had a record basis for explaining why we apply the NRIS standard. The fact that FERC has now changed its mind 3 years later and is no longer going to allow that under Order 2023 really is not relevant to this case, I think for the reasons that Ms. Pasella mentioned. In addition, Order 2023 actually, and I believe it's, I don't have the paragraph cites in front of me, Order 2023 actually permits individual transmission providers to come in and explain to FERC why they may need to still apply the higher standard. So it's not a foregone conclusion that SPP will not, even in the future, be able to apply the NRIS standard. And I'll also note, and I think this was noted, we have that issue on appeal. So whether that portion of Order 2023 ever goes into effect is still unknown. So it should have no bearing on this case.
Can I ask, so
Sure.
One thing I would love to hear a little more about is, one, when you apply the de minimis policy, right, in a situation where you have multiple 2.9% upgrades in a row, you can get to, say, a 10% overage, and the SPP policy says no upgrade is required. But if the first one had been 3% or 3.1%, it would say upgrade is required. Can you just as a practical way of when is an upgrade required, can you help me understand how that makes sense?
Yeah, I think the trouble with me being able to explain a practical way is I'm not an engineer, but SPP has made an engineering judgment that when a network resource service interconnection customer who on their host system has the right to flow power constantly, it's not, it's subject to curtailment only for emergencies, is going to have significant impacts on the SPP system. The other generators that SPP studied did not have that same impact for whatever reason. It could be that they didn't request network service. It could be that where they're located on the grid is sufficiently fortified that we don't really have to worry about that. SPP has determined that certain overloads can be managed, others can't. And when you have this sort of stacking, as they suggest, we might get up to 50 or 100%, that's where the regional planning process comes in. SPP looks at the region's transmission system, identifies constraints that are going to cause reliability problems, and proposes a regional or even an individual transmission owner solution to that problem. They don't pay for that. That's paid for by customers in their transmission service. So SPP has made these determinations on an engineering basis that there are certain overloads that we can manage around. You can redispatch. You can take other measures. You don't necessarily need an upgrade every time there's an overload. And when those overloads stack up, it doesn't necessarily mean that the next generator in line is going to pay for it, because it could end up with a regional planning solution.
Okay, and then the other question is, assume I think it matters whether the upgrade to remedy a 13% overage is bigger and more expensive than the upgrade to remedy a 3% overage. Or if it's somehow off the shelf, you either got to put up another line or not that costs exactly the same amount. Do you know the answer to that?
No, you really have to look at the study and look at solutions. And in one of the studies that's actually in the record in this case, I'm not sure if it's in the joint appendix, the consultant went into detail about how they considered alternatives to one of the projects that Tenaska is being asked to pay for, and determined that the solution that they came up with was the most cost effective. And cost effective doesn't always mean cheapest, but it's most cost effective. So the fact that there's a 13% overload versus a 9% overload may or may not cause a difference in the upgrade. It just depends on the situation and the solutions that are identified. If I could just make one point to Judge Ginsburg's question about, well, if we go back in time now, why is there uncertainty? The reason that there's uncertainty as to whether the cost that they have now complained about paying, they would have to pay, is because the system changes. I mean, the system changes every day. Generators come online, generators retire, new transmission lines go in, transmission lines are taken out. So the universe of upgrades that Tenaska has been asked to pay for here may or may not ever be built if they don't pay for them. There may be different upgrades that get identified later if they were to, restore their previous level of service. So what they're complaining about here is the upgrades that they are paying for. And those upgrades, as Ms. Pisello pointed out, went away. They did pay for one energy upgrade, and they signed a facility construction agreement with the transmission owner. It was filed at FERC. FERC accepted it in February of 2024. So for at least 4 years now, they've been operating without having paid for virtually any of the upgrades that were needed to provide their level of network service, which again is an uninterruptible level of service on the AECI system, but it impacts SPP. And again, that testimony is in the record. And one final point, just if I may, I know I'm over time, but SPP also presented evidence in this case that in real time, we've actually noticed a problem since the Tenaska Clear Creek facility went online. And that's at JA 153 and 154. And I'd invite you to take a look at that to show that this is not just conjecture, it's not just hypothetical. SPP has actually been suffering impacts on its system since this generator rushed through the queue and went into commercial operation. Thank you.
Thank you.
Thank you. I'll be brief. I think it's important to keep in mind that all of these upgrades and overloads that we're talking about only exist because Southwest used the wrong system study in assessing the impacts of the Clear Creek project. Network resource service, which again, Clear Creek has not asked for and will not receive on the Southwest system. Both councils mentioned that order number 2023 is irrelevant. I think that's untrue. And FERC has asked this court to basically disregard order number 2023, and it's relied upon cases like XL and Brooklyn Union, which do hold that the court should not consider a subsequent agency decision to invalidate a prior decision. But this court has held that it may consider changes in agency policy when considering a current appeal. And order number 2023 is without question a major change in policy by FERC. And I would just cite the court to the Con Ed case, which all of the parties have cited in their briefs. But on page 284, the court does say we have sometimes remanded if the agency has changed the rule underlying a decision pending review. And that is clearly what's happened here. Counsel for FERC talked about the reliability issues. Judge Ginsburg, you mentioned the cost causation question and the impacts. If I may just read you one line from FERC's own order number 2023 that speaks directly to the issue that counsel raised. FERC said, we find that any significant impact would generally be captured by an energy-only study, which would ensure that any reliability impacts on the affected system are mitigated to accommodate the interconnection of the affected system interconnection customers' proposed generating facility to the host system. I mean, that's exactly our argument in black and white, and it's the exact opposite of what counsel just said. And this is FERC speaking here. So the bottom line is we think that FERC has expressly declared that studying an interconnection request using network service standards results in unjust and unreasonable rates. And that's exactly what Southwest did here. So we think that allowing FERC's order to stand in this case would be upholding rates that FERC itself has declared are unjust and unreasonable. And we think that result really should not stand.
Super. In your brief, in your gray brief, your response to FERC's suggestion that the case is moot is along the lines of, yes, we downgraded our request to service only, but it wasn't voluntary.
That's right.
Why it doesn't have to be voluntary to be moot?
Well, Your Honor,
Maybe not.
to my understanding, we've never seen a case where a party has to allow itself to be rendered insolvent in order to preserve an appeal and avoid mootness.
As of right now, your request is for interruptible service. And all of the large sums of money that are discussed in the briefs you're not obligated to pay.
Well, Your Honor, right now, today, my client is being deprived of utilizing network resource service, a far more valuable level of service on its host system, Associated Electric System, for one reason. And that reason is it was ordered to pay $87 million on Southwest system, and Southwest is going to study my client's interconnection based on an unlawful study standard, the network resource standard.
For that reason, you've downgraded the request. And you're going to be, by your own representation, likely going to be seeking network service from Associated, I don't know when.
Only if this court vacates and remands can we do that.
Why you can you can remain on this, well, I'm not sure I understand that. Why can't you remain taking interruptible service from Southwest
We can,
while you're?
we're not taking any service from Southwest. We're not interconnected.
Associated.
We can
And
only
then
take,
upgrade your request. And in fact, if you started over, it'd be governed by the new rulemaking.
well, we're not sure how the new rulemaking will turn out, but what our argument
But
is,
this one's not very helpful.
yeah, our argument is that FERC got it wrong in this case
Yeah.
and that
I understand that. But
allowance.
if this case is moot,
Well, respectfully, I don't think the case is moot because again, I think that Clear Creek is suffering harm.
you said, well, it's not speculative because you're going to seek service, network service.
We cannot do that though, if we have the threat of further network service studies hanging over our
I
head,
get
which
that.
will result in costs we can't afford to pay.
But it's been represented that these studies will not be the governing studies when you later make your network upgrade request.
We don't know that for certain, but we do know.
Well, they have to study it as of the time you make the request.
But they shouldn't have to study it at all. That's the point. There's already been an energy-only study, and we're willing to pay the upgrades based on that energy-only study. The notion that Southwest is threatening to restudy the project based on network service standards, that's what we say is illegal. And that's what they're threatening to do. And that's what this court has the power to prevent. And that's what FERC says should happen.
I think you pointed to things in the 2023 order suggesting that that's not what will happen, right? That what will happen is that you will be evaluated for the service that you request.
Well, Your Honor, that assumes that the Order 2020 appeal runs its course. But as of today, Southwest, and today being as represented in intervener's brief, Southwest is saying that they will restudy the Clear Creek project based on network resource service if we seek to upgrade our level of service on our host system. And that's what got us in this problem. That's what resulted in the $87 million of upgrades. And until they're told, no, you cannot study Clear Creek using this improper level of service that Clear Creek hasn't asked for and won't receive, we've got a problem. And that's why I would urge the court to conclude that this case is not moot. It's a harm that my client is suffering today. It's unable to pick up the phone and call Associated Electric and say, we want to upgrade to network resource service because we're going to be studied by Southwest using the improper and we think unlawful level of service, the network resource level. And that's what resulted in all of the upgrade costs that we're talking about today.
Just one last question on the other issue.
Okay.
As my question suggested, assume I think it matters whether the upgrade you were required to pay for was more expensive because you were the last in line instead of the first in line. Is there evidence in the record that that's actually the case?
Your Honor, I'm not aware of evidence to the record along those lines either, but I do think it's important to note that other transmission providers screen out those pre-existing overloads, and Southwest isn't doing that, of course, and that's what we say creates the situation where we've got this imbalanced overload that we've got to pay 100% of.
Counsel, are you aware of any prior case, either law case or just instance, in which a utility provider has built before knowing what its costs were going to be?
I'm not aware of that situation.
This is a kind of
That story is quite a bit more complicated than counsel led on. I mean, the Clear Creek did commence construction about a year after the initial study. In the initial study, Clear Creek was only assigned energy-only costs. It was about $30 million. And then Southwest, based on a higher acute customer dropping out of the queue, did do a restudy. But in that restudy, they took about a year instead of the required couple of months, I think it is, and they added back 45 megawatts of power that they had just erroneously lost. And that is why the costs ballooned from $30 million to over $100 million.
When you say erroneously lost, you're not referring to the loss of one part of the load.
It was on a different system, but yes, it was 45 megawatts of power that they did not, 4,500 megawatts of power that they did not consider in the initial study. And that is what caused the network resource services to explode in the restudy. And yes, that did happen after Clear Creek had begun construction.
It's because some service taker went away.
That's correct. That's what triggered the restudy. But what caused the ballooning of costs was the erroneous omission of 4,500.
Okay, so those are two different things.
Two different things.
Okay.
My only point is that restudy process conducted by Southwest was really defined by negligence and gross errors.
Thank you. We will take the
Thank you.
case under advisement. Case is submitted.
Case number 23-5118, James Connell III, appellant versus Central Intelligence Agency. Mr. Kaufman for the appellant, Mr. Pullum for the appellee.
Thank you, Your Honor. Good morning. Brett Max Kaufman for the plaintiff appellant, James Connell. In light of all the record evidence in this case, the CIA's GLOMAR response is simply not credible. In its brief, the government hardly engages with this evidence. And in its declaration, it doesn't do so at all. Instead, the government takes the position that this court has already held, by implication, that the only way to defeat a GLOMAR response is through the waiver-based official acknowledgement doctrine. But this court's cases do not say that the CIA always wins unless it makes a waiver. Instead, they say that at the summary judgment stage, contrary record evidence can defeat the logic and plausibility of a government FOIA response.
But do you say that essentially the CIA's declaration has issues because it doesn't explain how the information would be respecting to intelligence or any type of national security issue?
Well, we don't take issue that the broad topic of the request could be protected under exemptions 1 or 3, but I do think that the declaration is deficient in a lot of ways. It does not really explain at all how what will be revealed by it acknowledging the existence of records will actually be revealed. But I think that the reams of evidence here mean that the government shouldn't really get a second chance to explain that, because it's just simply not credible that they could defend that secret. And, you know, that's the principle that the Second Circuit applied in Flores, that relevant evidence counts in a FOIA case. And it's not limited only to evidence that meets the official acknowledgement test, which again is a waiver doctrine. To reject that principle would be essentially to rewrite the FOIA statute. It would be to rewrite the summary judgment standards that apply to all civil litigation. And the CIA's argument has no limits. Its position is that no matter how much relevant evidence there is in a case, a court must bury its head in the sand and refuse to consider anything that doesn't come from the agency itself. But as Flores explains, that position makes no sense. In this case, the evidence overwhelmingly shows the CIA has additional records that are responsive to Mr. Connell's request. And when plausible deniability becomes implausible, like in this case, the court should reject the agency's GLOMAR. Turning to this principal theory, for more than 40 years, this court has held that government agencies are not entitled to summary judgment in FOIA cases if their affidavits are called into question by contradictory evidence in the record. As this court said in Gardels, courts must consider, quote, whether on the whole record, the agency's judgment objectively survives the test of good faith, specificity, and plausibility. In other words, the question is, with all the evidence considered, is the agency's justification for secrecy logical or plausible? Or, as the court put it in Gardels, does it make good sense? Just like in other civil cases, evidence is relevant in a FOIA case if it has probative value to the ultimate question. Now, critically, of course, the court might weigh evidence from different sources differently in different cases. But the key point, and the point of Flores, is that it must consider all of it, not just evidence that is provided by the very same agency that's arguing for secrecy. As the Second Circuit put it, the contrary result would be a court deliberately burying its head in the sand to relevant and contradictory record evidence solely because that evidence does not come from the very same agency seeking to assert a GLOMAR response in order to avoid the strictures of FOIA.
So what about, I appreciate the argument. We have these cases, Frugone, Moore, and others that essentially say, it seems like the analogy would be if the FBI had said over and over, the CIA had operational control over these 14 detainees at this exact time period at Guantanamo Bay. Frugone would say, CIA can still issue a GLOMAR response. I'm just not sure how this case is distinguishable from that principle, which does seem pretty well established in our case law.
Yeah, it's a good question. So, Your Honor, Frugone, I think, doesn't quite go that far. So Frugone involved, of course, the OPM letter and CIA employment and a FOIA request about a person who claimed they were a CIA agent, and they sought to use the letter from OPM to defeat the CIA's GLOMAR response. But there, the court really did base its holding in waiver. The last line of the opinion is, we hold that only the CIA can waive its right to assert an exemption to the FOIA. So there was a point at which this court started talking about official acknowledgement and the defeat of FOIA affidavits in terms of waiver. And that really started with Fitzgibbon in 1990. And since then, the court and litigants have pushed the argument in those terms. And of course, waiver is a distinct concept from regular summary judgment standards. It's about whether an agency took an affirmative act or said an affirmative thing to no longer be able to rely on a FOIA exemption in the first place. But our argument and the argument that the Flores court
It
accepts.
just seems like that just becomes, the point of my first question is it seems like your conception just becomes an end run, a backdoor around those waiver holdings. Because your whole point is if every newspaper in the world is saying, or even another agency and Congress are saying, CIA is doing this, but the CIA hasn't. If we think about it as waiver, CIA wins, and we think about it your way, CIA loses.
Well, I don't think it's quite that simple, Your Honor, because one, we're not talking about newspaper articles. And if we came into court in this case or any other, and we cited the New York Times citing anonymous sources, and we said, look, it's obviously true. Both the Post and the Times are saying it's true. It must be true. Appreciate it. That would be a case where.
So would the FBI and Congress.
Well, I think Congress is a good example. So if you look at Military Audit Project, there was a congressional report that put into evidence, and the court never mentioned waiver in that case, and it sort of considered how weighty is this. And in that case, the CIA, which had 8 affidavits in that case, one of them actually took on the Senate report, and it said, look, read the Senate report. It's just based on anonymous sources and newspapers. It's a committee reading the newspaper. So that's the kind of evidence that a district court judge could say that has no weight, especially against a CIA claim of harm or something like that. Compare that to this case, where we have the definitive account of the government's torture program in a Senate report, where there was process involved that allowed the CIA to respond to the report substantively, underwent a declassification review headed by the President of the United States. So no word was released to the public. There's 6,000 pages that are still redacted. So we're just talking about an executive summary. So the credibility of that kind of document is leagues away from what was at issue in Military Audit Project. There was a Senate report also at issue in Salisbury. And it makes sense that this court and the district courts in those cases said, compared with what the CIA claims and defends its response on, those things don't defeat it. But in this case, I think you can't look at the Senate report without understanding that it is an authoritative document. It cites documents that, for the proposition that the CIA had some measure of operational control, the report cites documents that the CIA produced. So the CIA in this litigation has said, yeah, whatever the report cites, we're actually giving you those things because they do relate to our operational control.
And how
So-
does the Zubaydah case relate from the Supreme Court?
Zubaydah relates to our official acknowledgement argument, which is, again, I just want to emphasize, distinct from this argument that we make based on Flores. But the relevance of that case, I think, is that in that case, of course, involved a state secrets claim the government made. And the individuals that were asked to give testimony that the government got in the way of in that case were former contractors of the CIA. So one really significant piece of that is that they were former contractors, because under this court's cases and others in the Second Circuit, as a general rule, former officials cannot acknowledge on behalf of an agency. That's almost textbook official acknowledgement law at this point. But the Zubaydah court said, actually, given the circumstances here, that doesn't make sense. These guys were central participants in the events they're being asked about. And therefore, they can acknowledge for the CIA in this instance. And it was the government, of course, in that case, making the claim that they could, and that their acknowledgement would be tantamount to an official acknowledgement by the CIA itself. And as we point out in the briefing, that case is actually consistent with the reasoning of this court's case in Amezian, where the court held that a lawyer for a detainee would be officially acknowledging information on behalf of the government if they went out to a foreign government and revealed information that they had acquired during litigation. A very sensible ruling, and one that makes clear that the official acknowledgement doctrine is not as strict as perhaps some of the cases and some of the government's arguments make it sound.
Do you actually get any more documents than what you already have, if we root for you?
Well, unfortunately, that's one of the pitfalls of this kind of litigation, Your Honor. as the most famous example being ACLU v. CIA, where in a great opinion by this court, the Glomar response was rejected, and we went back and we never saw a single document after 2 more years of litigation. But the government did acknowledge the existence of hundreds of documents, and it described them. So I think that shows the importance of actually holding the government's feet to its fire when it issues a Glomar response. Simply because down the road we may not see the documents we're actually interested in seeing doesn't mean that the government gets to hide behind a Glomar response and not even engage in the normal FIRE process. That really makes no sense.
Let me just ask you to clarify something. Regarding the Senate Select Committee report, on your second, I guess more refined request or something, the CIA gave you a portion or gave you the itinerary for a visit or proposed visit. And what was the distinction that caused them to release that but not anything else?
I don't know, Your Honor. You're going to have to ask the CIA about that.
So there was no explanation.
Not that I'm aware of. We didn't litigate the case in the district court, so it's possible somewhere down there is an explanation, but I don't believe we got an explanation. And in my experience, you don't get much of an explanation when they re-release a document. Simply just give it to you.
So the report, what was in the report that would relate to, you're familiar with the report?
The Senate report.
That would, yes.
Sure.
That would relate to the proposed itinerary. Was it mentioned in the report? Was it described?
I believe the citation in the sentence that says the CIA had operational control during this time, it cites to a background memo which also had an itinerary next to it, or combined with it. And so that is the document cited for the very proposition that the CIA did have operational control. But I think it's a good point to actually look at the released document, because on its face, it doesn't necessarily point to operational control. There's a lot of redactions in there. And I think that's why it's significant that the CIA acknowledged that it was related to its operational control, not operational control generally, but responsive to Mr. Connell's request about the CIA's operational control. There was also the Memorandum of Agreement, which is JA 417. That document, the Camp 7 commander during the military commissions testified that that was a document that governed Camp 7. And that document in unredacted text says that it sets out the duties and responsibilities of the 2 agencies, DOD and CIA, signed by the directors, that concern the government's detention of terrorism suspects at Camp 7.
Yeah, I think, but what the MOA says is that from September 1, 2006 forward, the beginning date of your request, the detainees are DOD's responsibility.
Well, it does say that it's in some terms in the unredacted text. Of course, there's a lot unredacted. There are other responsibilities, including communications with Congress. And this goes to our point about the breadth of the term operational control. The government has treated it all along like an on-off switch. Either the CIA had operational control or it did not. We don't think that that is the most sensible way to understand that term. I mean, just think about if someone asked, who has operational control of this courtroom? Is it Your Honor? Is it the clerk? Is it the marshals in the back? Is it the administrative office? It's the clerk. But I think we would all say that there's some measure of operational control belongs to everybody. And I think that's the most sensible way to read Mr. Connell's request, not as the government wants to, as an on-off switch. That means if the CIA either does or does not have that control. And once you accept that, the idea that the CIA has absolutely no more documents responsive to this request is just simply not credible. It's just not a credible response given the evidence.
Now,
But they didn't say they have no more documents. That's not the issue, right?
Well, if they do have documents, I think this is ACLU v. CIA. If it's clear from the record that they do have additional documents, this Glomar response cannot be sustained. To that point, though, during the military commissions, testimony was elicited that from a DOD, from a Camp 7 commander, that the DOD had operational control and the CIA did not. But that's an interesting response given the Glomar response, because Glomar is supposed to protect both sides of that secret. So either the Camp 7 commander is wrong and lying, that there was no operational control, and the CIA should just say we had none and we have no records, or we're correct, and that was simply an interpretation of operational control that is different from the most sensible reading of it.
Well, it's coming from a different agent.
Absolutely, we understand that, and we're not
Which
relying.
very well explain different understanding of what operational control is.
It could, and I think that actually makes sense given our theory that operational control is a broad term. But back to
How do we adjudicate the right way to think about the request, right? So it sounds like you want us to read it to mean basically any documents about CIA's connection with Camp 7 during this time period. It's not really quite what it says, and it seems like the government interpreted it far more narrowly about, do you have documents about the nature and extent of CIA's operational control? And what they're saying is, if we respond to that, that's going to reveal something that's currently classified, which is whether or not we have such a connection.
Right. Well, one, I think just first principles, the requester in FOIA is in control of the request. So I think that's point number one. Number two, of course, now the CIA is saying X or Y will be revealed, and it has such a narrow meaning that there's this great secret that's going to be revealed if we say, hey, we have more documents. But if you actually look at the declaration in this case, they say exactly what we're saying. They say Glomar kept secret a, quote, potential classified connection. That's at JA 43, paragraph 26. At paragraph 20 in JA 4041, the CIA searched for records about an unclassified, quote, relationship with Camp 7. So our understanding of the term is confirmed by how they treated the request behind closed doors. So now they're in litigation, and they say that the sky's going to fall if they acknowledge they have
A
records.
little squirrely, but I think the declaration never says connection with Camp 7. It repeatedly says connection with the subject matter of the FOIA request, which is not exactly illuminating. But it's not as favorable to you as what you just described, I don't think.
Fair enough. I read it differently. I mean, they say the connection with the subject of the request, which is CIA operational control at Camp 7. I'll take a little squirrely rather than just squirrely. But so I think right there you have the CIA understanding it in normal terms. This just confirms the ordinary reading of the request. It's not a real stretch. It's not trying to pick and choose things that the CIA said that help us. It's literally how they handled the request once they took it in and had to go about the normal part of FOIA, which is figure out what records this person is asking for and go find them within the agency.
You understand that under the ACLU case versus CIA, that they have three options with respect to releasing them, doing the Vaughn Index, or doing the no number, no list. But are you requesting that we urge them to do one of the three, or that they just be allowed to participate in these options?
Well, I think just like in that case, we're asking this court to reject the Glomar response. And again, the government has options on remand. There's no denying that, and we're well aware of that. Of course, this court in ACLU v. CIA did caution that if they choose to go the no number, no list route, the court would want to see a particularly persuasive affidavit. Because it's just, to use your term, Your Honor, a little squirrely of a response to say, well, we have documents, but the depth of our interest is classified. It just becomes a little bit slippery. And given this court's admonishments in Vaughn, going all the way back there, and ACLU v. CIA, it's understandable that the court would want to see a really good explanation for why that stuff remains secret. Of course, the codas to a lot of these litigations actually suggest that that's not what's going to happen in this case, Your Honor. ACLU v. CIA is one where, again, they identified or described at least hundreds of documents on remand. Flores itself is one where the court didn't even reject the Glomar response. It just said the district court needs to consider it. And the CIA ended up releasing some of those documents. So, the CIA does hold tight to these Glomar responses, but once they're defeated, the sky doesn't fall. They are able to engage in a normal FOIA search like most agencies do every day in FOIA. I do want to draw the court's attention, and I know my time's up, just one document that is in the record that we think actually is a responsive record that was not produced. And perhaps the court could look at that document and decide that defeats the Glomar response on its own. And that's the interagency meeting memo. It's a JA 359. It was obtained by the ACLU in FOIA litigation 10 years ago. It's discussed at our opening brief at 4041. And that describes a November 2006 meeting involving the CIA and other agencies discussing several security issues concerning the 14 high-value detainees at Camp 7. And it says that the group reached consensus on several issues. It also says that individuals working on detainee issues at Camp 7 would require CAA code word security clearances. So that's a document that should have been responsive in this litigation, that was not produced, and that could and should defeat the agency's GLOMAR response on its own. Thank you.
Had been released, did you say?
I'm sorry? It was released in other FOIA litigation, but not in this litigation. Thank you, Hunter.
Thank you.
Good morning, and may it please the court, Thomas Pullum for the Central Intelligence Agency. This court has held that if a FOIA requester attempts to compel the disclosure of protected information on the ground that the information is in the public domain, the requester must establish that the exact information at issue has been officially acknowledged by the same agency from whom the information is sought. Disclosures of similar information or disclosures made by other government entities, the court has held, do not suffice. But in this appeal, Mr. Connell argues that none of those cases matter because a FOIA requester can simply avoid the strict requirements of the official acknowledgement doctrine by arguing that the presence of information in the public domain makes the agency's attempt to invoke an exemption not logical or plausible. This court should not permit the requester to do through the back door what this court's precedent bars at the front. The official acknowledgement doctrine is based on the recognition that confirmations from an intelligence agency itself are fundamentally different because they are given unique weight and eliminate all doubt on a question. Those same principles foreclose Connell's argument. Further, Connell offers no argument that the documents he relies on contradict CIA's assertion that confirming or denying the existence of responsive documents would disclose information relating to intelligence sources and methods. Because that assertion is logical and plausible, the agency's GLOMAR response is supported by two independent FOIA exemptions. We ask that the judgment be affirmed.
All right, so counsel's argument is that it's not plausible in light of the various things that have appeared in the Senate Select Committee report, et cetera. And are you saying that that's not relevant, or that plausibility is not established?
So I'm saying that
Non-plausibility.
yeah, this court has a doctrine to address that exact argument, that public information prevents the assertion of a FOIA exemption. That's the argument here, so those cases apply on their face. And the same principles are involved. That there's a critical difference between confirmations from an intelligence agency and statements from others, that those confirmations are given unique weight. And the court has said that kind of those considerations apply with greater force in the intelligence context. And this court has rejected several times attempts to kind of end run the official acknowledgement case. In Knight, the court addressed an argument that statement from the State Department, even if it weren't an official acknowledgement, undermined the GLOMAR response. And the court said, no, that statement from this other agency is far different from an admission by the intelligence agency. And that's what makes it logical and plausible.
So if the SSCI report just flat out says that the CIA had operational control over these detainees, if that statement was from the CIA, if that had been in one of the documents the CIA produced, would you concede that a GLOMAR response would be implausible?
I think it depends on
the request is for documents about whether CIA has operational control during this time period. And a CIA document, just one, says CIA had operational control.
Yeah, I mean, I think we would, it would certainly be different, and it would change the scope of waiver, and the question would just be whether there's anything kind of else outside. And Wolf is instructive in this regard, I think. In that case, there was a request for documents about a certain individual, a Colombian politician.
I believe that Judge Garcia is very pointed and very narrow in the question he's asking you. And you're giving us a response that kind of says, look at other documents in the totality of the circumstances, essentially. But if he's referring to one specific document that has that statement, that's the response.
Then it would waive with respect to what's incorporated in that statement.
Right. Okay. So I think a lot turns here on how CIA is interpreting the scope of the request. I think one way to ask this is that in the background memo to the itinerary for the visit on JA 320, it says, once at Gitmo, CIA's endgame is to assist DoD in any way possible in the military commission process, while at the same time protecting CIA equity. Isn't that an official acknowledgement of some CIA connection? Or are you drawing a distinction between that kind of a statement and operational control over these detainees?
So I think that this gets to what I was trying to get at before, is that waives the Glomar response to the extent of the acknowledgement, which is that CIA has this kind of very limited role that doesn't necessarily go to operational control, but with respect to that it kind of will support DoD in the commission process. The memorandum of understanding that counsel referred to says that DoD and CIA will coordinate on public affairs matters. So CIA
how do you understand operational control? So there's a FOIA request. You say you cannot confirm or deny whether you have documents responsive to the request, and it's a little bit unclear just what CIA interpreted the request to be.
Well,
the clearest articulation.
It was unclear what it meant. That's why the agency asked for clarification. And the requester came back with it said, I want to know what operational control means, and here are 7 things. And the agency said, okay, we are looking at what operational control means through the lens of these 7 examples. And the agency did a search for documents that reflect an acknowledged connection between the agency and the request, and it released those. Anything that goes to a further relationship that's not reflected in what's been acknowledged, that's what's protected by the Glomar response. So it protects whether CIA has an additional relationship to the control of this facility beyond what is reflected in the documents that have been released. And that, I think—
CIA chose not to classify or redact the portion of the torture report in that respect about its operational control.
So this court has addressed that very argument in one of its foundational cases in this area, which is Afshar. In that case, the requester pointed to books by former CIA, or I forget the exact agency, but former agency employees, and said, well, those books have been subject to pre-publication review. So the agency could have stopped information from coming out. And the court said, no, that's not enough to make it an official acknowledgement. So the same thing—
predate Zubaydah?
It does, but Zubaydah did not involve FOIA. It referred to FOIA cases as an analogy, and an imperfect one at that. And I don't think there's anything in Zubaydah that would call for an overruling of FOIA cases, given that it wasn't in that context. And I want to be clear about one point with respect to that case, is that in the context of the state secrets doctrine, it was asking, would these disclosures by contractors cause harm and harm to the national security? And the court said, well, yes, they would cause some harm, kind of analogizing it to official disclosure, but that doesn't mean that disclosures by contractors, which were likely to be given some level of credibility, would be the same as disclosures by the agency itself. That's a full other step that the court didn't reach. And I think there's no reason to think that the court kind of was silently overruling a well-established part of official acknowledgement cases, given that it said, it made clear this isn't actually an official acknowledgement case. This is just by analogy. We're drawing on the same ideas that certain disclosures carry a risk of harm, greater risk of harm than others. So their contractors gave some, but it's not the same necessarily as the agency.
And how does time impact disclosure of the risk? For example, if you're in 2024 thinking about a document that was available or acknowledged or actually even made in 2012, and yet that particular situation has passed and it's a historical event now, is there a difference in how you would respond, or would you just say?
No, so that's something, when we're looking at harm to the national security, that's something that an original classification authority would take into account when deciding whether this information is classified. But I want to make one point that I think is very important, is that this GLOMAR response was justified on both B1 and B3. The question under B3 is only whether there's a statute that qualifies, and there's no dispute here that the National Security Act qualifies. And then the question is, does the information fall within that statute? And so the question when we have the National Security Act is only, would it reveal information that relates to sources and methods? There is no requirement of harm to the national security under B3 because Congress has already made the determination that these releases should not be made. That is the harm. It's already captured in the coverage of the statute.
Can you give us your response to the interagency memo, which I was also going to ask about? I think there's two questions. One is just your response to opposing counsel's argument that it should just defeat your GLOMAR response. And the second is, why wasn't it produced in this case if it was already public?
Two responses. One, I'm not sure that it, and I didn't hear an argument that it relates, that it provides any information about CIA's operational control kind of through the lens of the 7 identified factors. As to why it wasn't produced, I couldn't, the agency didn't address whether it thought the argument or the document was
well, presumably if you're right on the first point, then it wasn't responsive.
Yes, it could also be that it wasn't in the, I mean, the agency described how it did a search, which was a search of a particular database collection of documents that had been disclosed or deemed kind of appropriate for release. And it might also not have been in that collection, and we don't know if the agency actually has that document. But I would like to make a point about, counsel tried to say, well, there's something about whether the other disclosures that are relied on, the committee report or, other things are especially credible. One that doesn't address or account for Frugone, where OPM, the agency in charge of kind of information about executive branch employees, said CIA has your employment records. That would appear to be a very credible assertion, notwithstanding that this court held that the CIA could not be compelled to disclose information whether it had records. The other case is Fitzgibbon, which involved a congressional document. The document in that case disclosed the location of a station. That document, the district court said, cited CIA cables for that information. So it's an exact analog here. The congressional body cited agency documents and said, based on that, we're representing this fact. This court said not an official acknowledgement, not an official disclosure because it was made by Congress.
And how does operational control relate to intelligence source or the method?
Yeah, so it relates to intelligence, I think most clearly methods and activities. Activities is one of the terms in the executive order. Intelligence methods are the means by which an agency carries out its intelligence gathering mission and the authorities for those means. And activities has a kind of similar definition. It's the means by which agencies gather intelligence and kind of specific operations that are carried out. So this is clearly, and Petitioner, or I'm sorry, the requester offers no argument that what the Senate committee characterized as the operational control of this facility would not qualify as.
But the declaration doesn't specifically say anything that you're saying here.
It says that it defines activities and methods and says that this information would disclose information about intelligence methods and activities. So I think the import is fairly clear. Now, if the court thought that the declaration were deficient because it didn't go into enough detail, then the proper solution would be not to say that the GLOMAR response it can't be used and force the agency to disclose classified and statutorily protected information, but rather remand to give the agency an opportunity to fill in those details that the court thinks is missing. Given the kind of real stakes at issue here, that would be most appropriate. But if there are no further questions, we ask that the judgment be affirmed.
Okay, thank you.
Thank you.
Thank you. So the CIA mentions a few cases in its favor that we think actually help us. So just quickly to hit on them. Knight is a case where at the end of the opinion, the court actually does consider whether our Flores argument, it says notwithstanding official acknowledgement, does this State Department press statement undermine the CIA's GLOMAR response? In that case, they said no. But again, that just raises 2 points. One, that weight will play out differently depending on the evidence available. There, the court found that the State Department press statement didn't outweigh the arguments the CIA made in its declaration. But here, this is an exceptional case where they do. Fitzgibbon, the CIA mentioned as well, that one also helps us. There, the court did not reject the Senate report out of hand. It said that it related to a different time period, and it simply didn't acknowledge the information at issue in the request. They considered it. They said it didn't match. In Offshore, that case also helps us. As Your Honor pointed out, Judge Childs, Zubaydah came afterwards, so that has to be accounted for. But even more directly in the case, in Offshore, the court compares the weight of the statements of former officials against media speculation. And says those are kind of the same thing. So the court was making a judgment that that wasn't that credible in that instance. And we think that all the evidence here does add up to undermine the GLOMAR response and show that there are more documents that the CIA has here. Judge Garcia, you asked a question that I think there's one thing in the record that is relevant to the answer. I just wanted the consequence of answering the response here for the CIA. There's a fully withheld document in the record. I think it's JA 77. They basically describe it in general terms and give no more information about it, don't produce it, don't redact it. I think it's very hard to understand as a matter of logic and plausibility how the government can release that document, but then the sky will fall if it acknowledges it has additional documents. And so even on the government's own terms that it's already released everything that is unclassified about this connection, I think it's simply not a credible argument.
77's a Vaughn index, is that what you meant?
That's right. That is the agency essentially giving that brief Vaughn description instead of providing a redacted document. I think it's a 20-something page document. I think on the Vaughn, they mislabel it as 30-something. They corrected that later, but it does beg the question of how the agency can provide a document that's responsive that says absolutely nothing about anything. And then harm will come if the agency acknowledges that it has additional records in its possession. So again, I think that this is not a case about an end run. This is about a case pushing the credibility of the agency and to the breaking point and asking the court to play along. And I think as the court did in ACLU v. CIA, there comes a point where the court has to say no to these games of secrecy. And this is one of those cases. Thank you.
All right. I've heard your arguments. We'll take it under advisement and the case is submitted.
Case number 23-7059. Darrell, Wilcox, and Michael McGuire, individually and as representatives of a class of participants and beneficiaries in and on behalf of the Georgetown University Defined Contribution Retirement Plan, the Georgetown University Voluntary Contribution Retirement Plan appellants versus Georgetown University et al. Mr. Bloom for the appellants, Ms. Zaharsky for the appellees.
May I proceed?
Good morning, Your Honor, and may it please the court. My name is James Bloom from the firm Schneider, Wallace, Cottrell, Konecki, on behalf of plaintiffs appellants Brian Wilcox and Michael McGuire, who bring their claims on behalf of the Georgetown plans. And we respectfully request that the court reverse the district court's decision denying leave to amend and remand the case to the district court with instructions to grant plaintiffs' motion for leave to file the proposed amended complaint. So ERISA, the Employee Retirement Income Security Act of 1974, was designed to protect employee retirement savings. And to achieve that purpose, ERISA imposed strict fiduciary duties of prudence and loyalty on those responsible for administering retirement plans, as defendants were responsible for administering the Georgetown plans at issue in this case.
And I would indicate that when you have a motion to amend, it doesn't seem that hard to have a court grant it and give you the opportunity to cure any deficiencies, but you just can't be futile. And it seems that here you're not alleging direct wrongdoing by Georgetown, that you're kind of putting together more of a circumstantial case, because you're using terms that say they may have failed to prudently damage and monitor the plan. And so that's where some of the rub comes, because do you just open it up where you have to get all your discovery to then prove your case without, on the front end, meeting your Rule 11 requirements, where you have done some discovery, you've done some investigation, and you then have enough information to support a plausible claim?
Well, Your Honor, I would respond to that in two different ways. I think that as the complaint alleges, there's both direct and circumstantial evidence of a flawed fiduciary process in this case. The direct evidence includes fees we know the plan participants paid, which in this case were more than 5 times the national median, according to the analysts and consultant studies cited in the complaint.
Some of that is even for issues with respect to standing, about fees paid into those particular plans, though, correct?
Well, Your Honor, let me take this one piece at a time, if I may. So the standing question is sort of a two-step question in this case. There's no doubt that the individual plan participants, the named plaintiffs in this case, Mr. Wilcox and Mr. McGuire, invested in some of the imprudent funds and paid the excessive record-keeping fees described in the case. The only question is whether they have enough standing to seek relief on behalf of all of the funds in the plan, or on behalf of the plan for all of the funds regardless of whether they invested in them personally. And there, the case law is unanimous in our favor, in plaintiffs' favor. You've got the Third Circuit's decision in Boley. I don't believe we cited it in the brief, but in preparing for this argument, I saw the Eighth Circuit's decision in Braden versus Walmart. Both stand for the proposition that once a plaintiff establishes that they have standing to bring relief on behalf of the fund for at least, or on behalf of the plan with respect to at least some of the challenge conduct, as long as there's a conceptual link, they can seek
I think
relief.
those cases say there needs to be more than a conceptual link, right? It says the same course of conduct. So for example, maybe those cases would apply if you invested in one of the plans and retail shares only were offered. And you said a prudent fiduciary would have secured institutional class shares for this and all the other funds that we also didn't invest in. Then maybe you could challenge that share class issue for funds you didn't invest in. But that doesn't seem analogous to what's going on here, right? You're not challenging, there isn't another retail class share that you invested in.
Well, Your Honor, I would argue that when you're talking about an investment lineup of nearly 400 investment funds like you have here, you're going to have a plan that is replete with problems in the way the funds were selected, including that. And I would say that turning back to the Braden versus Walmart decision, cases like this invariably rely on information at the pleading stage about what the participants can deduce from the publicly available documents. And here, I think the critical thing to consider is the Supreme Court's decision in Hughes versus Northwestern University, and then the Seventh Circuit's consideration of that decision on remand. Because there you had a startlingly similar alignment of problems with the way the plan had been managed. You had hundreds of investment options. You had retail share class funds in a plan with billions of dollars in assets. And you had multiple record keepers when the national standard is to have a single record keeper. Having multiple record keepers just inflates the fees that participants have to pay. And when you apply that to this case, you see all of those same problems. And the import of the Supreme Court's decision in Hughes is that when you have that alignment, when you have that set of problems, it's strongly suggestive of the fact that there was fiduciary imprudence and that cost the participants a significant
Just a
amount
little
of money.
more specific. So on your record keeping claim, the basic idea is you should infer there was an imprudent process because the fees here were really high and fees for other plans were lower, right? I think one difficulty for you that the district court focused on is that your own complaint acknowledges in paragraph 64 that the record keeping fees for plans differ on a whole host of factors. And then when you turn to comparing the fees here to the fees charged to other plans, you don't include any details about any of those factors. Can you sort of address that point that the district court made?
Well, I would say this, Your Honor. I think that the district court might have read too much into paragraph 64 of our complaint. These record-keeping services are standardized nationwide. And as we alleged, I believe in paragraph 63 and paragraph 62, that the primary differentiator between record-keeping service providers is price, that they provide precisely the same lineups of services for different plans, and that it is possible for plans to achieve the same level of services at a lower price. And that's really the core of our allegation there.
I still don't get something. Your pardon me, individual plaintiffs didn't invest in any of the funds that suffered from defect in that, the alleged defect in that fund, correct?
No, Your Honor, that's not quite right, respectfully. The plaintiffs did both invest in funds that had unnecessary fees and that had been imprudently selected. There are a host of problems with the nearly 400 funds in the plan.
What about the ones in which they invested?
Yes.
What are the problem? What do they invest in, and what is the problem with that investment?
Well, the plaintiffs, for example, plaintiff Wilcox invested in the TIAA traditional annuity,
Right.
which has the 10-year lockup provision and the 2.5%
Okay. So
withdrawal fee.
how is that affecting him now? What's the harm?
Well, he can't take his money out without suffering these. He can't even move his money to a different investment option if he thinks that equities or bonds might be a better place.
He's
to
never
put
alleged
his
that,
money.
there's no allegation that that's what he wants to do, or that he's about to do that if only he could. Nothing to that effect.
That's correct, Your Honor, because we don't think it's frankly necessary to allege that the particular plaintiff would do that, but for these withdrawal restrictions.
Well, you might want to read the Lujan case again on imminence. The harm has to be either present or at least imminent, right? And when does this, that's just to make sure I understand the restriction. If he wants to move his money today into a different fund, he cannot do that. And if he, does that apply also at retirement time?
At retirement time, he can take an immediate withdrawal, but then he pays the 2.5% surrender charge.
Okay.
And
He's not at retirement time.
he's not at retirement
He
time.
just wants to move his money into a different fund.
Well, I think the way to look at this, Your Honor, is, the implication of defendant's argument that he should have made the request prior to filing the suit.
No, I'm not suggesting that. If the rules prevented, there would have been futile to require him to make the request. But he's made no allegation that this is what he will do if only he could.
I think that whether he would want to do that today or whether he'd want to do that a year from now, it really makes no difference.
Well, then you ought to reread the case. It's got to be imminent.
Well, I think that
A someday
here,
plan. That's the phrase. A someday plan or intention to do something is not sufficient.
I think this is a very different circumstance because in the Lujan case, you had individuals who were concerned about potential access to the natural environment. This is this man's retirement savings, and it's locked up in this fund. And whether today, tomorrow, 3 years from now, he decides he wants to get that money back, he can't do that.
There are hundreds of cases applying Lujan, literally hundreds of cases. You obviously are familiar with Lujan itself. Thank you.
Thank you.
But, and that imminence requirement has been a constant. There has to be an allegation of that sort. And in fact, now we see these in the environmental cases that follow Lujan. The organizations, the Sierra Club and so on, they're always careful to point out that a person has been using the facility, wants to continue or would no longer be able to do so. Something that is concrete in the present or immediate and certain future.
Well, I think that part of the difference here is that he needs to be able to make his decisions about where he wants to have his retirement savings, depending on changes to the market that he may not be able to foresee today.
Well, he didn't even allege that.
I think that is we would consider that to be a legal argument. I'd also note that retirement is sort of inevitable. This will come to pass. It will affect him sooner or later.
Well, that certainly won't qualify as it's true, but it's not.
Right. Well, I mean, I think that it's a present ongoing violation of his rights to access his own retirement savings and invest it in a way that he sees fit without incurring this 10-year lockup charge. I'd also note that neither the defendants nor the district court cite a case ever in the nearly now 50 years since ERISA was adopted holding that a participant lacks standing to challenge a fund that they actually invested in. Here, I think that going back to a question that Judge Childs asked earlier, how do we infer a fiduciary process violation? Here, I think you have to look at the allegations in the complaint as a whole, read the complaint holistically. And what you see is the record-keeping administrative fees as much as 5 times higher than the national average or the national median for comparable plans. The multiple record keepers, the 400 investment options, the lower cost investor share class funds that were available, the TIA variable annuities, which had many layers of unnecessary fees, the traditional annuity with its 10-year lockup period and withdrawal fee, and the inaccurate information in the 5500s that were provided to plan participants and to the Department of Labor. All of that, when you read those allegations together, suggests that defendants were asleep at the switch and not performing their fiduciary obligations.
Thank you. You may proceed.
Good morning. I'm Nicole Saharsky for Georgetown. So 2 different district courts took a close look at the complaints here and determined that they failed, both because of lack of standing on some of the claims and because of failure to state a claim. And they gave plaintiffs the opportunity to replead, essentially a third bite at the apple, and plaintiffs didn't take it, but instead came to this court. I think that the primary argument that plaintiffs are making here are not about the allegations in this complaint, but perhaps about what other courts have done. And so I just want to address that at the outset. Every court that has addressed claims like this have recognized that they are context specific, that the duty of prudence is context specific. It depends, as the statute says, under the circumstances then prevailing, under the plan then prevailing, what would a prudent person do? And the Supreme Court in the Hughes case reaffirmed that. It said this is a context specific inquiry. And so when you look at the claims in this case, there are different claims in other cases. There are different plans at issue in other cases. But the claims in this case failed to state a claim, and that's what the 2 district courts that did the hard work here determined. In particular, the court looked at the allegations, that the particular complaints, the particular counts in the complaint, and said there's not an overall cause of action under ERISA for overall plan mismanagement. There has to be a claim of breach of fiduciary duty. And what are the exact claims that are at issue here? And so the court started with the claim with respect to record-keeping fees and said, okay, the fundamental problem here is that there are allegations that the fees are too high, but how does that compare to the services that are offered? And so the court, with respect to the first complaint, the court in the first decision said, I've got 3 problems here. First, that there's not a comparison to plans that are like this one, that have services like this one. And second, in particular, an important feature of these plans is that they include TIAA annuities, which are long-term plans that are more expensive to record keep. And there's no allegations that these other plans with lower fees have the TIAA annuities. And then the court said there's a third problem, which is there's this claimed fee of $35, but no factual support for it. And so the court gave plaintiffs an opportunity to replead and then said, none of those deficiencies were cured. And I think the court appropriately said, we just need some benchmark here. And that's the same thing that many other courts of appeals have said in, for example, the Matusik case in the 8th Circuit, the Matney case in the 10th Circuit, Common Spirit in the 6th Circuit, the Albert case in the 7th Circuit. And I guess what I would say is—
those all motions to dismiss, not summary judgment?
Yes, those were motions to dismiss.
So, counsel, what is your rule? So what level of detail about other plans should be required before a claim like this can proceed?
So Twombly and Iqbal says that there has to be something that pushes the allegations from possible to plausible. And in the context of record-keeping fees, what would push it from possible to plausible is some allegation about other plans that are like this plan that have the same level of services. And so if you look at what the plaintiffs in this case have alleged, they talked about 5 other university plans, but they don't even tell us the record-keeping fees for 4 of those 5 plans. So we don't know what the fees are. And then they don't tell us the services for the other plans.
Are the services, maybe you could explain what you mean by services, but is that publicly available information?
Yes. So I think the plaintiffs are talking here about record-keeping services. I'll note that in the district court's opinion on page 31, this is in the second opinion, the court has some frustration because the plaintiffs are kind of inconsistent about what services and what fees they're talking about, but I understand them to be talking about record-keeping fees. And I think there is, obviously the plaintiffs had the information about the fees in their plans because they're participants in the Georgetown plan. there is a significant amount of publicly available information about other plans. We gave an example in our brief about the Pepperdine plan. We gave other examples below. Now, the district court said, I'm not going to look at that stuff unless plaintiffs pleaded it, right? Because I have to just focus on the complaint and focus on the allegations there and take them as true. But there is publicly available information that exists, especially because, as Your Honor know, there are a lot of other university cases that have been brought against other universities. And so a lot of information has come out in those cases.
Right. So in this case, they have the 5 examples of the other universities. If they alleged each of these pays only $35 for record-keeping services, and each includes a mix of mutual funds and annuities, like Georgetown's plan, is that enough?
That's a lot better. Probably it's enough. It would just be a question of, does it have like a TIA annuity like this plan? But I guess what I would say is we're not even close to that here. Like we're very far away from that as a line. I mean, here they tell us for each of these that there was one record keeper, but they don't tell us what the funds were, and they don't say whether they were TIA annuities. Actually, it kind of suggests that at least one of them didn't have TIA annuities. So we're not saying that, there aren't allegations that, potentially could be pled that would be sufficient. Obviously, there are some cases that have gone forward, like in the Seventh Circuit, for example. We're saying that the allegations in this case are really sparse and just don't push over the
I wanted
line.
to ask about that because the Seventh Circuit Hughes complaint seems quite similar. And I'm just wondering how you would have us distinguish that complaint, or if you really just think that decision is wrong.
I think it is distinguishable, and the answers for why it's distinguishable are in the Hughes decision itself. The Seventh Circuit there is very careful in parsing through the allegations in the complaint, and the ones that it focuses on that are not present here are, first of all, that there were other record keepers that were equally capable of providing the same services. The second was an allegation that Northwestern had not solicited bids or sought rebates. And then the third, which the Seventh Circuit found very important, is that there was an allegation that Northwestern actually had consolidated and reduced the fees, which showed that it was doable in those circumstances. And I'd urge you to look at the Seventh Circuit's opinion because it goes very specifically through the allegations, and it makes very clear that this is a context-specific decision. And the other thing it does, which we find, I think, very helpful, is that it distinguishes between that case and a prior case in Albert. There's this case, Albert versus Oshkosh, which was also a record-keeping case in the Seventh Circuit. And the Seventh Circuit explains, here's why the allegations in this case are sufficient, but the allegations in this other case aren't sufficient.
Right.
And so
for the third reason you gave, I'm quite sure that if one of your clients made a change, you would ask us not to use that as evidence of imprudence in sort of a hindsight way. And on the first point, you're right. This complaint doesn't use the words equally capable. But paragraph 62 says, there are numerous record keepers in the marketplace capable of providing a high level of service to large defined contribution plans like plans. To me, that seems very generic, but it also seems that's just another way of saying there's other equally capable record keepers out there. So do you disagree with that?
Well, I don't think it says equally capable. I think it is, as you say, pretty generic. But I guess if I were looking at the allegations in this complaint, as opposed to, for example, the Hughes complaint, there are pages and pages about record keeping and the kind of equally capable and ability of others to record keep, whereas we're just talking about one paragraph in this complaint. So if you just look at the sheer amount of allegations kind of on this point, they are much more detailed in the Hughes case. And I do think at the pleading stage, an allegation, this third allegation that you spoke to, this allegation that it could be done is something that raises the specter of plausibility. Now, do I think at trial that would establish imprudence? No, but where we are now is that there needs to be something that pushes into plausibility. And I guess the point I would make about kind of the Seventh Circuit cases and perhaps some of the other cases is that there is the same legal rule that is being applied, and it's just different outcomes in different cases because of different allegations. And the allegations here are just sparse. They're just very sparse about what Georgetown, allegedly did wrong. And if you look at this kind of question, you asked, Your Honor, about what is the legal rule that we would apply? This legal rule that you need some similar plan, comparator, benchmark, whatever you call it, that is throughout the courts of appeals. That's in the Sixth Circuit in Common Spirit. That's in the Seventh Circuit in the Albert case, and in the Hughes case, I think also says it. It's in the Eighth Circuit. It's in the 10th Circuit. The Third Circuit said it in Sueda. So we think the legal rule is the same. It's just the application of that legal rule to this particular case. I guess the other thing I'd say is that there are 3 different counts here, and while plaintiffs I think sometimes jumble them all together and say, oh, courts have allowed these to proceed. I think where some courts have allowed them to go forward on the record-keeping fees is on the record-keeping fees. But with respect to these other counts, there are not cases that allowed them to have gone forward. For example, on their too many options claim, like there are too many options, that's been routinely rejected at the motion to dismiss stage, including by the Hughes remand, in the Hughes court in the Northwestern case on remand. NYU, Yale, the Northwestern case, all rejected because of no pleading of injury as a result of that. And that's something the district court pointed out here, and the plaintiffs just didn't have a response. I think the last thing I'd mention is the court had some discussion as to potential issues with standing. We do think that there's a lack of standing just on two particular claims, the Vanguard share classes, because there's no investment in those claims for the reasons you stated, Judge Garcia. And then with respect to the TIAA annuity withdrawal restrictions, essentially for the reasons that you stated, Judge Ginsburg. And so I guess at the end of the day, what I'd say is, these courts had these two district courts had this complaint in front of it. They did their absolute best of working their way through this complaint and said, in the first time around, here's what you need to allege plaintiffs, and then came back and the plaintiffs didn't do it. And then the plaintiffs didn't want their third chance to do it. And I think, it's been 6 years with this complaint, and we would urge this court to affirm.
Thank you. You have 2 minutes for rebuttal.
Thank you, Your Honor. I'd just like to respond very briefly to two points my distinguished opposing counsel made. First, on the question of too many investment options, I respectfully suggest that defendants get the holding in Hughes 2 backwards. In Hughes 2, the court noted that offering a wide variety of investment options was indicative of prudence, but that the Supreme Court and the Seventh Circuit in Hughes both, and the remand in Hughes, both reversed the motion to dismiss because too many investment options had been offered. Both the Seventh Circuit and the Supreme Court cited that specifically as evidence of imprudence. And as far as a benchmark about when do you go from having a wide range of investment options to when you have too many, the Seventh Circuit on remand in Hughes noted favorably that Northwestern had amended their plan to reduce to something like 35 investment options from well below the 400 or so that they and the Supreme Court found had been too many. The other point is about a benchmark and what's in the complaint. Defense counsel argued that there's information in the public about what the record-keeping fees were. And that is true. There is information about in the public about what the record-keeping fees were, but there's a claim here that's well supported by the evidence cited in the complaint that the information provided to participants was incomplete and in some ways inaccurate. So we have based the complaint on the information that's out there, but we also note that we have grave concerns about that information. I think that if you look at the comparison the Seventh Circuit made in Hughes between that case and Oshkosh, it's clear that this court should reverse applying the same rationale here. All of the allegations that the Seventh Circuit said were present in Hughes are present in the first amended complaint in this case. We have, I can assure you, pages of allegations in the complaint about what record-keeping services are, what the appropriate price for that would be. We do allege, I think the distinction is whether equally capable of providing the high level of services. The phrase we used in the complaint was capable of providing the high level services. And with that, thank the court for its time. Thank you very much.
The case is submitted.
Honorable court has been adjourned until Thursday, April 11th, 9:30 a.m.